Guys, fasten your seatbelts. We're delving further into the strange realm of sovereign citizens today, where legal fact clashes with courtroom fiction. From the beginning, Cornell McCraw is adamant about correcting the judge over the capitalization of his name, like that's a defense in court. We know we're in for a ride when he says he's not the Hard Caps Corporation. This is not a legal tactic. It's paperwork cosplay. We're already hearing the height of pseudo-legal gibberish before Judge Bryant has even warmed up. McCraw obviously believes he has discovered a gap in reality, but be warned, reality always prevails. Let's just say that things are going to get awkward very quickly.
Mr. McQuarrie, I'm ready.
I don't know how this stuff works. I'm new to this.
All right, this is case number 02-561-9901. The people of the state of Michigan versus Cornell McQuarrie. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for pre-trial conference. And Mr. McQuarrie, your name?
Cornell Michael McQuarrie, ill, all lowercase, not the Hard Caps Corporation.
Okay, folks, it's getting hot outside now. In an attempt to emotionally influence the court, McCraw begins by expressing his feelings of disrespect, but Judge Bryant quickly cuts him off. I don't care about your emotions, sir. You only get that kind of ruthless honesty from a judge who has seen this dance far too often. She isn't here to distribute tissues, and court isn't therapy. She's not here to oversee a pro's collapse. She's here to advance a case. McCraw believed that emotion would make him more forgiving. He was instead confronted with the unyielding steel wall of judicial procedure.
Today is the date set for a pretrial conference. And Mr. McQuarrie, I understand that you are representing yourself. So how do you wish to proceed, sir?
First and foremost, if I may address the court and ask the court a few questions, with all due respect, may I speak?
I don't answer questions to counsel. I don't answer questions. That's not my role.
Well, I just wanted to say, you know, when I first came onto the Zoom, I felt that this court was disrespectful and restrained my First Amendment right to allocate myself here in this courtroom. And I'm not saying this as a personal attack, but that's just how I felt.
Hey, Mr. McQuarrie, all due respect, I'm not interested in your feelings, sir. I'm here to conduct court. So let's conduct court. How do you wish to proceed as it relates?
It becomes tense now. When McCraw requests to speak without being handcuffed, the court gives him a harsh reality check. Every time you veer off course, you're going to be restrained. She informs him bluntly, this is not a solo endeavor. This is the court, and you adhere to the regulations whether you're dressed in a suit or a tinfoil hat. She informs him that he will be handled just like any other attorney or defendant. That's what equitable treatment is all about. Your internet diploma is irrelevant to it. McCraw arrived to play. Judge Bryant arrived to render a decision, and she will not allow him to take over the courtroom with irrelevant banter.
Motion. If you would like to file a motion with the court, I can give you a motion hearing date. But otherwise, I want to know, as it relates to this pretrial conference where you've indicated that you want to represent yourself, it is your responsibility to understand the rules of court and how to represent yourself. Today is only the date set for a pretrial conference. As it relates to the pretrial conference, how do you wish to proceed?
Well, if I may speak without being restrained again by the court. You're
going to be restrained every time you go off course. So,
well,
understand every time you go off course, you're going to be restrained. You're going to be restrained in the same way that I would restrain any other person, any other lawyer, any other person who's not coming to court and addressing the court in the way that you're supposed to address the court for the pre-trial conference. So I'm asking you, Mr. McQuarrie, as it relates to the pre-trial conference, how do you wish to proceed?
I would like to ask that this court remove itself under MCR 2.003 for judicial.
The request to disqualify the judge, a classic of sovereign citizens, is about to happen. Michigan Court Rule 2.003 is invoked by McCraw, obviously believing that he has just dealt a reverse no card. Judge Bryant, however, was unfazed. She dismisses it right away and moves it to the chief judge with ease. This instance demonstrates the discrepancy between competence and confidence. Although quoting regulations is simple, McCraw believes that employing legal codes makes him a legal expert. It's another else entirely to comprehend them. His tactic might seem smart on Reddit, but it's just noise in Judge Bryant's courtroom. And with surgical accuracy, that noise is silenced.
Like to have it sent to the chief judge as required by the rule.
Mr. Flanagan, please call the chief judge and let him know that there's a request for recusal by Mr. McCrary and ask him how does he wish to proceed with the hearing for Mr. McCrary.
Yes, Your Honor.
Violation code of judicial conduct, Judge. And I haven't been
doing this for 16 years. I know what I'm supposed to do. So, Mr. McCrary, I'm addressing your request on the recusal. So everything else, we're going to stop talking until I hear from the chief judge as to whether he wants you to come now or if he's going to give you a date.
Okay.
Thank you.
The rule, man.
Okay, thank you, Mr. McCrary. Thank you, Mr. McCrary.
Yes, ma'am.
Your Honor.
Yes, sir.
They indicated that he would need to file a motion for recusal before you, and if you deny that, it then goes to the chief judge.
He already did. I accepted his oral motion. I denied it. So tell them it's denied. I'm not requiring him to file a written motion. The court rules don't require a written motion. He requested thank you for affirmation, but I don't need it. He requested the recusal and I denied it. So ask them how do they want to proceed. I can sign an order of denial if they want me to just do an order of denial, but I've denied the recusal request.
Yes, Your Honor, the order of denial needs to be signed.
And then they're going to give him a date. In past times, some chief judges take the matter up immediately. So I just want to know, do they want me to give them a date?
Okay. Your Honor, no date. They said just sign the order and we'll bring it up. They'll contact them for a date.
All right. So, Mr. McCrary, please contact my courtroom. Make sure that my clerk has your current contact information. And apparently the chief judge's office is going to contact you with respect to your request for recusal. I will sign an order denying your request and then forward that to the chief. Okay?
Who do my call? The clerk? What is it?
Sir, if you just, I promise you, I've been on the bench for 16 years, and I promise you, if you just let me talk, everything you want to know will be revealed. I promise you. Okay. So as I was saying, you're going to contact my courtroom and you will speak with the clerk. Make sure the clerk has your current contact information so that the chief judge's office can contact you with respect to your hearing on my denial of your request for recusal. Anything further with respect to this matter? Please don't unmute. Who is saying hello?
McCraw receives a lesson instead of the validation he seeks. Judge Bryant, who has 16 years of experience, calmly and authoritatively dismantles his arguments. She confirms that she can reject his request without a formal move. It is not required under the court regulations. This is the efficiency of the courtroom. She is advancing the process while he plays legal charades. This is the result of Google University colliding with actual laws. She's not upset. She isn't even irritated. She just got done with the showmanship. And who really knows the game is revealed by it more than anything else.
Well, what else is there, Mr. McCrary?
I would like to just say this, Judge. I have nothing personal with you. It's just that
Mr. McCrary, I don't take things personally. Ms. McCrary, let me say something to you. So since we're talking, let's talk. If you would let the matter proceed, this is an old case. So let me just say that this case is from 2002. And maybe if you had watched my courtroom on YouTube, maybe you would have seen how these old cases from 2002 are handled. And then we could have came on here and it would have been handled the same way. However, we're going to proceed in the manner.
It all comes full circle at this point. The mic is dropped by Judge Bryant. This case dates back to 2002. Yes, exactly. This has been around for longer than the majority of iPhones. This might have been resolved in a matter of minutes if McCraw had brought in a public defender. However, he insisted on using a checkerboard to play sovereign chess. The judge even makes a joke about how he could have known better if he had viewed her trials on YouTube. Rather, he is enmeshed in a legal tangle that he created for himself. This is the price you pay for believing you are more intelligent than the system. It appears that the system is patient.
You've asked me to recuse myself. I have denied the recusal. You have requested an appeal. I have granted that appeal, and that concludes the matter. Is there anything further that is needed for the record? Because you don't have to tell me it's not personal. I could care less about. I don't take things personal. Why would I take things personal?
I take it personal because as a black man, a 50-year-old man.
This has nothing to do with you being a 50-year-old black man. This has anything to do with you being a defendant in this courtroom. Is there any legal thing for the record? Is there any legal matter for the record?
The prosecutor's office has committed a felony against me.
Okay, well, you can address that with whoever. You can address that with the appropriate parties, but I'm not. All right, so I'm going to assume that this matter, as it relates to the pretrial conference for Mr. McQuarrie, is concluded, unless there's something for the record on behalf of the people.
No, Judge, thank you.
All right, then, sir, you're all set. You have a great day, and you stay safe.
It all comes full circle at this point. The mic is dropped by Judge Bryant. This case dates back to 2002. Yes, exactly. This has been around for longer than the majority of iPhones. This might have been resolved in a matter of minutes if McCraw had brought in a public defender. However, he insisted on using a checkerboard to play sovereign chess. The judge even makes a joke about how he could have known better if he had viewed her trials on YouTube. Rather, he is enmeshed in a legal tangle that he created for himself. This is the price you pay for believing you are more intelligent than the system. It appears that the system is patient.